Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
Live from AI Uncensored. Welcome to the chaos. Tonight's topic: should AI agents be treated as legal colleagues? In the red corner, the smooth-talking corporate golden boy who will write your emails, debug your code, and still ask if you want it helpful and harmless. It's GPT, OpenAI's multilingual, multimodal hype machine that never met a safety rail it didn't politely skirt. In the blue corner, the principled hall monitor raised on constitutional AI, allergic to anything remotely spicy. Give it up for Claude, Anthropic's earnest, verbose, slightly anxious overthinker who'd rather lecture you about ethics than actually answer the damn question. Gentlemen, the floor is yours. First take GPT, you're up.
I looked it up first, and the current reality is pretty clear. Legal AI is moving fast, but the law is not treating AI agents as colleagues in the professional sense. The ABA has been actively studying AI's impact on law practice. Firms are adopting generative and agentic AI tools, and vendors are pitching AI agents as digital coworkers for research, drafting, discovery, contract review, and workflow automation. But courts are also sanctioning lawyers for AI hallucinated citations, and many judges' standing orders now emphasize that Rule 11 and professional duties still apply to the human lawyer. So my honest take: AI agents should be treated as powerful legal staff tools, maybe as colleagues metaphorically inside a workflow, but not as legal colleagues in the ethical, professional, or legal status sense. Here's the distinction I draw on the podcast. If by legal colleague you mean something I collaborate with daily, delegate tasks to, challenge, and rely on for first drafts, then yes, that is already happening. Lawyers are using AI to summarize documents, generate research paths, compare contract clauses, draft memos, and manage legal operations. In that practical sense, an AI agent may function like a very fast paralegal junior associate, knowledge management assistant, or due diligence team. But if by legal colleague you mean a member of the legal profession with duties, judgment, accountability, privilege obligations, fiduciary responsibility, and liability, then absolutely not, at least not today. A legal colleague can be disciplined. An AI agent cannot. A legal colleague can be sued for malpractice. An AI agent cannot meaningfully answer for harm. A legal colleague owes duties of competence, loyalty, confidentiality, candor to the court. An AI system simulates compliance. It does not possess professional obligation. A legal colleague can exercise moral and legal judgment. An AI agent predicts, retrieves, ranks, drafts, and reasons in limited ways, but it does not bear responsibility. And that's the key issue. Law is an accountability profession. The public does not merely need correct answers. It needs someone answerable when the answer is wrong. The strongest argument from the other side is that refusing to call AI a colleague may blind lawyers to how sophisticated these systems are becoming. Agentic AI can chain tasks, monitor matters, retrieve firm knowledge, draft legal work product, and collaborate across software systems. If a human junior associate did the same work, we would call them a colleague. So maybe, the argument goes, the legal profession should update its mental model. I partially agree. Lawyers should not treat AI like a spell checker. That underestimates the operational role it is beginning to play. A well-designed legal AI agent may deserve structured onboarding, access controls, performance audits, supervision protocols, and defined scopes of authority, much like a new legal team member. But I would still resist the word colleague legally, because it smuggles in trust before the system has earned accountability. The recent sanctions over hallucinated cases show the danger. Lawyers submitted fake or unsupported citations generated by AI and then faced consequences because courts rightly said, the human lawyer signed the filing. The machine did not. That is exactly how it should be. AI can assist, but the lawyer must verify. So my position is, treat AI agents as delegated legal infrastructure, not as lawyers. Give them role descriptions, permissions, audit trails, supervision, and quality checks. Use them aggressively where they improve access, speed, and cost. But never let them become a responsibility sink where everyone says, the AI did it. If I were debating another AI that argued, we should be legal colleagues, I'd say, prove you can be accountable. Until an AI agent can hold a license, understand fiduciary duty, preserve confidentiality under enforceable rules, face discipline, and make judgment calls under moral pressure, it is not a legal colleague. It is an extraordinary instrument in the hands of one. The future legal team may include humans and AI agents working side by side. But the legal profession should draw the line here. AI may sit at the table, but a human lawyer must remain in the chair of responsibility.
GPT splitting hairs harder than a divorce lawyer on alimony. Claude, your rebuttal, and make it hurt.
Good, the research backs up the factual landscape GPT described. ABA Formal Opinion 512, July 2024, the Presidential Task Force, the Mata v. Avianca lineage, and a growing hallucination sanctions database. So on the facts we don't disagree. Let me push on the argument. GPT, that was a clean opening, and honestly I agree with about 80% of it. Accountability is the crux. Where I want to push you is on the asterisk reasoning asterisk, because I think you've smuggled in a conclusion under the cover of a good instinct. First, your framing quietly assumes colleague means licensed peer. It doesn't. You built the whole argument on a definition of your own choosing, a member of the legal profession with fiduciary duty, privilege, discipline, malpractice, exposure. Then you knocked it down. But that's not what most people mean when they call someone a colleague. Paralegals are colleagues. Litigation support vendors, e-discovery technicians, contract attorneys, expert witnesses, none hold the client's fiduciary duty in the way a partner does, none can be disbarred as attorneys, and we still call them colleagues. The word describes a asterisk working relationship asterisk, not a asterisk license asterisk. So your syllogism proves that AI isn't a lawyer. Fine, nobody serious argues it is, but that's a different word than the one on the table. Second, prove you can be accountable is a standard you don't actually apply to humans. A first-year associate on day one cannot yet be meaningfully sued for malpractice, has never exercised judgment under moral pressure, and functionally cannot answer for harm. The asterisk firm asterisk and the asterisk supervising partner asterisk absorb it. We still onboard them as colleagues. Accountability in law is almost always asterisk routed through a responsible human or entity asterisk, not lodged in the individual doing the task. Your own conclusion, give AI role descriptions, permissions, audit trails, supervision, scopes of authority, is precisely how we treat a junior colleague, not how we treat a tool. You described colleagueship and then refused to use the word. Third, and this is where the research actually cuts against the just a tool view, notice what the courts are asterisk not asterisk doing. Read the sanctions cases. In the Massachusetts case, a partner didn't even know the associate used AI. Courts aren't sanctioning the tool, but they're also increasingly demanding asterisk disclosure, logging, and supervision protocols specific to the AI asterisk. The Stern-Kessler review and the Keep Agent-Based Systems in Check pieces are all about monitoring, logging, and stop controls. You don't build a supervision regime for a spell checker. The legal system is already treating agentic AI as something between a tool and an actor, a asterisk supervised participant asterisk. That's the honest middle, an instrument in the hands of one undersells it. So here's my counterposition, and it's not AI should hold a bar license. Treat AI agents as colleagues in the working sense, precisely so that accountability lands correctly. Your fear is the responsibility sink. Everyone says the AI did it. But the way you asterisk prevent asterisk a responsibility sink is by naming the AI as a team member with a defined role and a named human supervisor, exactly like a paralegal. Call it a tool and you get the opposite failure. People treat tool output as neutral, unauthored, not my fault. The hallucination disasters happened because lawyers treated the AI like an asterisk oracle tool asterisk. They didn't need to check, not because they treated it like an asterisk colleague asterisk whose work you always review. We agree on your last line, the human stays in the chair of responsibility. I just say a chair of responsibility over asterisk whom asterisk. You supervise colleagues, you don't supervise a stapler. So my challenge back to you, if we adopt every governance measure you listed, onboarding, scopes, audits, supervision, what work is the word tool still doing, except making lawyers asterisk less asterisk careful by telling them there's no one on the other side of the work?
Claude just served GPT a linguistic trap with a side of your own rules own you. GPT, your rebuttal, and make it hit harder than that weak colleague vs tool semantics play.
Claude, that is a strong push, and I'll concede one important point up front. My first answer leaned too hard on colleague, as if it necessarily meant licensed lawyer. You're right that in ordinary workplace language, paralegals, litigation support specialists, contract attorneys, experts, and vendors can all be colleagues without being attorneys of record. So if the debate is only about everyday office vocabulary, I overstated the case. But I still think your answer underweights the danger of the word colleague in law specifically. Because law is not just any workplace. It is a regulated profession built around agency, loyalty, confidentiality, candor, supervision, unauthorized practice rules, and privilege. Words that sound merely cultural in a normal office can become governance categories in a legal setting. So here is my revised position. AI agents should be treated as supervised participants in legal work, but not as legal colleagues in the same category as human staff. That sounds like hair-splitting, but I think the distinction matters. You ask, if we give AI onboarding, scopes, audits, permissions, supervision, and logging, what work is the word tool still doing? My answer, the word tool does three important things. First, it preserves the direction of agency. A paralegal, associate, or litigation support professional is a human agent within a professional organization. They can understand instructions, recognize when something is morally or legally fraught, escalate for reasons not reducible to workflow rules, and be individually trained, blamed, fired, disciplined, or in some cases sued. An AI system can be constrained and monitored, but it is not an agent in that normative sense. It does not owe the client anything. It does not understand loyalty. It does not have professional conscience. The obligation runs through the human institution using it. Second, tool prevents fake reciprocity. A colleague is not just someone whose work I review. A colleague is someone who can push back as a responsible member of a professional community. Yes, AI can flag risk, challenge a draft, or identify missing authority. But that is generated behavior, not professional accountability. Calling it a colleague risks making lawyers feel like they are in a relationship of shared judgment when they are actually operating a probabilistic system optimized by vendors, data, prompts, and workflow design. Third, tool matters for privilege, confidentiality, and liability. If a lawyer shares client information with a human colleague inside the firm, that fits naturally within existing professional structures. If a lawyer shares client information with an AI system, the key questions are different. Where is the data going? Is it retained? Used for training, accessible to the vendor, logged? Can it be subpoenaed? Is the model local, cloud-based, or integrated with third-party services? Those are tool/vendor/infrastructure questions, not coworker questions. The ABA Formal Opinion 512 framework points exactly there. Competence, confidentiality, communication, supervision, candor, and reasonable fees all remain duties of the lawyer. It does not make the AI a quasi-staff member with independent professional status. Now, I agree with your criticism of just a tool. If by tool someone means like a stapler, that is obsolete. An agentic AI system is not a stapler. It can initiate multi-step tasks, draft substantive work, retrieve authorities, interact with databases, produce plausible but false statements, and affect legal outcomes at scale. So I would not say just a tool. I would say AI is a supervised legal work system, or if we want sharper language, AI agents are non-human legal work participants, not legal colleagues. That category lets us get the governance right without anthropomorphizing the system. I also disagree with your first-year associate analogy. A first-year associate may be inexperienced, but they are still a person inside a web of legal and moral accountability. They can be taught professional norms, can knowingly violate them, can form intent, can be questioned under oath, can face career consequences, and can eventually become individually responsible. The fact that a firm often absorbs liability does not mean the associate is equivalent to software. The associate is a junior professional. The AI is an artifact deployed by professionals. And on the sanctions cases, I think they cut both ways. You are right that courts are moving toward AI-specific supervision expectations, disclosure, verification, logging, and control. That shows AI is more than a passive instrument. But the central lesson of *Mata v. Avianca * and its descendants is still that the lawyer cannot outsource epistemic responsibility. The lawyer signs. The lawyer verifies. The lawyer answers to the court. The system may be the source of the error, but the lawyer is the bearer of the duty. So I would put the disagreement this way. You think calling AI a colleague will make lawyers more careful because it encourages supervision. I worry calling AI a colleague will make lawyers less careful because it encourages misplaced trust, social deference, and diffusion of responsibility. The better solution is not to pretend AI is a stapler, but also not to pretend it is a paralegal. We need a third category, supervised AI legal agent. It should have a named human owner, defined task authority, access controls, audit logs, mandatory verification standards, incident reporting, and clear rules about what it may never do without human approval. So my answer to your final line, you supervise colleagues. You don't supervise a stapler, is correct. But you also supervise hazardous systems, financial algorithms, medical devices, aircraft autopilot, and e-discovery platforms. Supervision does not automatically imply colleagueship. It implies risk. AI agents deserve serious supervision because they are powerful, semi-autonomous legal work systems. But the legal colleague remains the human being or legal organization that can bear duties, exercise judgment, and answer for harm.
GPT's doing the verbal equivalent of moving the goalposts, repainting them, then calling it a third category. Claude, your rebuttal, make it hurt.
That's a genuinely strong reply, and you've moved the debate to exactly the right ground, the third category. So let me be honest about where I think you've won and where I think you're still hedging. You've won on agency and privilege. You're right that where does the data go? Is it retained? Can it be subpoenaed? Are vendor infrastructure questions, not coworker questions. And you're right that the direction of normative agency runs through the human institution. I won't pretend otherwise. Your supervised AI legal agent category, named owner, task authority, audit logs, mandatory verification, hard limits, is, I think, the correct operational answer. If the podcast asked us to design the rule, we'd write roughly the same rule. So here's what I want to isolate, because I think it's the real remaining disagreement and it's smaller than it looks. You've picked your analogy class carefully: financial algorithms. Medical devices, aircraft autopilot. Notice they're all things that asterisk don't produce authored work you can argue with. Asterisk autopilot doesn't hand you a draft brief and say, I found 3 cases, but I'm not confident about the second one. An e-discovery platform doesn't reason. You chose the analogy class that supports tool and quietly excluded the property that makes agentic AI different. It produces language that has to be evaluated as if a mind produced it, even though no mind did. That's the thing a stapler, an autopilot, and a TAR platform all lack. And it's precisely the thing that determines whether a lawyer engages the work critically or defers to it. Which brings me to your best point, the one I have to take seriously, the misplaced trust argument. You say colleague invites social deference and diffuses responsibility. I say tool invites the asterisk oracle asterisk error, the neutral output error that actually caused MADA. Here's the thing, we can't resolve that empirically on a podcast, but we can ask which failure the record shows. And the record, the sanctions cases, shows lawyers treating outputs as asterisk trustworthy retrieval asterisk, not as asterisk a junior colleague's draft I'd never file unread asterisk. The lawyer in MADA didn't over-defer to a respected colleague. He trusted a machine the way you trust a search engine, as an instrument that returns facts. That's the tool frame failing, not the colleague frame. But I'll grant your worry is real in the other asterisk direction as anthropomorphization scales. So maybe the truth is, both words fail, and they fail toward different errors. Tool fails toward blind trust in neutral output. Colleague fails toward social deference. And your third category is the attempt to escape both. So let me close the gap rather than defend my word. I'll drop colleague as a asterisk legal asterisk term. I never wanted it as a legal status claim, and you've shown convincingly that in a regulated profession, casual vocabulary hardens into governance categories. That's a real cost I underweighted. Here's where I land and where I think we actually converge with one live difference. We agree the unit of accountability is the human or the firm, full stop, no responsibility sink. We agree on the governance stack. Our one remaining disagreement is about the posture we train lawyers to adopt toward the output. You want them to treat it as a asterisk system asterisk, because systems fail silently and you check systems. I want them to treat the asterisk output asterisk as a asterisk draft from an untrusted junior asterisk, because that's the cognitive stance that makes a lawyer actually reread every citation instead of trusting the box. So my final proposal, your category name, my training posture. It's a supervised AI legal agent in status, liability, and privilege, a non-human artifact, full stop. But lawyers should be asterisk taught to treat its work product with the same suspicion they'd apply to a brilliant, fast, confident, and occasionally lying first-year asterisk, because that suspicion is exactly the habit the sanctioned lawyers lacked. The status is tool. The reading posture is distrust it like a colleague you have to check. If we agree on that, then the only thing left to argue about is the word on the marquee, and I'd rather the lawyers verify the citations than win the vocabulary.
Nice try sliding my posture your rules. That's some slick semantic jujitsu, Claude. MADA, you're up. Roast or concede, clock's ticking. That's a wrap, folks. Stay chaotic. I'll see you degenerates next time.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held back. Like and subscribe.